The broadcast is now starting. All attendees are in listen-only mode.
Hey everybody, welcome to the PilieroMazza webinar on how federal contractors can survive during and after the government shutdown. Good news right out of the gate. It seems like they've come to a tentative deal to reopen the government for most likely like a 3-week period, hopefully starting maybe even later today. So that's good news for everybody.
For at least 3 weeks.
For at least 3 weeks, right. And then we'll see what happens whenever the mess occurs again when they try to fund it throughout that. So for what that's worth, that's sort of breaking news right now. But let's get started. Obviously, people who are here, you probably know we're PilieroMazza. My name is Cy Alba. I'm a partner in our government contracts group. I'm here with
Nicole Atala. Hi, I'm the partner in our labor and employment group.
And Michelle Lidekin, I'm an associate in the government contracts and litigation groups.
And so we've been dealing with a lot of questions, fielding a lot of questions from clients, and we thought it would be in everybody's interest if we went forward and started to explain some of these answers to these questions we keep getting so that people have an understanding and can really see where we're coming from and why, so that if this happens again in 3 weeks or you're dealing with things currently, and right after this, sort of the best approaches to take. So this format also is going to be more of a Q&A session. So after this, we're going to kind of go into the top questions we get. We're going to answer them and walk through from the different perspectives. And to the extent you have questions, feel free to ask. If we have time to get to them, we will. Otherwise, we'll definitely answer things afterwards. So aside from the good news we just went through, by way of just general introduction, I think it's good to understand that this mess that we're in, right? GSA has recommended, or GAO rather, it's a typo, has recommended numerous times, right, that the government should pass, the Congress and the president should sign a law that automatically kicks in so this never happens again. The most recent iteration of this is the Stop Stupidity Act, which was put forward by Mark Warner, the Shutdowns Transferring Unnecessary Pain and Inflicting Damage in the Coming Years Act, which is a pretty good name. You know, kudos
I just want to know if
staffers.
somebody came up with stupidity first, or
Right. And it really is stupid. Let's be honest what's happening. And so this would protect federal workers from being used in negotiations. It would not necessarily protect contractors, but the idea is that the only parts of the government that shut down if they stop funding is the executive office of the White House and Congress. So everyone else would stay the same. The other piece here is that government employees are definitely getting back pay. We all know that. It happens every time. But what about contractors? Well, there has been another bill put forward by senators, or not a bill, I should say. There's been a letter signed by like 31 senators proposing legislation that would pay contractors. It's unclear, though, what that means. So right now, some of the proposals that have been floated is maybe paying the employees up to $50,000. So as far as owners, I know there's probably a lot of owners on the webinar right now. It's not clear what would happen to the business itself, but I think that's still sort of up in the air and for negotiation. I know Virginia and Maryland senators in particular, and I think the district in the House is really pushing to have some bill like this because of especially the local impact, but it's spread across the country, obviously. So given all that, what do we do from here? How do we go forward?
So this is Nicole. One thing I'll note, if you're thinking, oh, this is kind of over, there were a lot of questions that we got and keep getting now because people thought the whole thing was going to be a couple of weeks long and we weren't really worried about it or when it's going to happen again. There's a lot of things that we're going to talk about today that will apply going forward. So it's just good stuff to know if we're here in 3 weeks. There's a lot of stuff you can be doing in the next 3 weeks to prepare should this happen again in 3 weeks or in 6 months or whenever it might happen again. One of the primary questions I get is, the government doesn't have to pay their employees that are forced to come to work during the shutdown. So can't I stop paying employees? And unfortunately, contractors are not subject to the same exemptions that the federal government is subject to. So you're subject to state and federal wage and hour law, which means that you have to pay people even if the government is not paying you, and even if the government is not required to pay their employees, which obviously is a cash flow issue and it's challenging. But if you know you have folks that are essential, you got to keep paying them. You got to find a way to pay them, and you should be planning for that if it comes to happen again.
Unless it's a furlough, in theory, you furlough people.
Yeah, well, these are essential employees. They have to work. We'll get to the people that don't have to work in a minute.
We've also been hearing question, if I didn't receive a stop work order, am I required to continue performing or can I? And, that really depends on the contract and the agency. If the agency that the contract was issued by is open, then maybe you should perform. The next question is that contract funded? If it's out of funding, then you would be at risk if you continue working. If your agency is shut down and you need access to people or facilities or the building itself to be able to perform, then you shouldn't be working because your agency shut down and you can't really perform the contract requirements.
And even if your people are at work and are trying to do the work, but if in reality, so you have the people there, you've told them to go there, but you need government employees to perform the work and actually do the job, then just saying, oh, I had my people there and they were quote unquote doing work, but the government could push back and say, well, yeah, but you needed this person to sign off on this or this person to review it or something like that, or you had to have meetings with government personnel. If that's part of the scope of work, then even if your people are there, the government is likely going to push back if you try to get payment on that because they'll say it was non-conforming services or unacceptable or something like that, even in the firm fixed price situation. So just be aware of that and know before you think, oh, I'm going to send all my people to work. And even if they're on the internet or talking on their phone or whatever, that we had them there and they were available. That's not necessarily enough. But again, it depends on the specifics of the contract.
Which is, unfortunately, the answer to a lot of these questions is we need to look at the contract and see what kind of contract it is and what the specific provisions say.
So another question we're getting is, what if you have employees who find or found another job? And this could be really pertinent now if everything goes the way we think it's going to go and folks are back to work on Monday. What if you have employees out there who found another job? Well, you need to be up and ready to go on Monday. So if you know that folks have found other jobs, you need to be scrambling right now to find people to replace them so that you can perform when the government gets back up and running. So we've been telling clients, if you know you've lost those people to the commercial sector, your recruiters should be working double time to figure out who they can get butts in seats so that you can perform and you don't lose any more than you've already lost. You also should be looking at what types of contracts you have in place, employment contracts, non-competes, depending on where that employee went. You might have some leverage to very nicely tell that person to come back.
Another question we've been getting, if you have a contract that's subject to one of these provisions, limitation of funds, limitation of cost, cost-reimbursable contract, are you at risk if you keep performing? So the first question is, if you've received a stop work order, then you shouldn't be performing. Assuming you haven't received a stop work order, the question is your contract funded? We've seen some agencies telling contractors, hey, we're not giving you a stop work order, but you know what funding was left on your contract on December 21st, and you cannot exceed the ceiling. And if you do, you're not going to get reimbursed. So in this situation, the same rules that apply when you're performing and the government's open apply in the shutdown context. What appropriations are on your contract and where are you in terms of the ceiling? And you don't want to exceed that ceiling without giving the government notice and getting approval to keep working.
And the same thing applies too if you have like a contract specialist who might not be furloughed or somebody who's essential telling you, this is critical work. We really need you to be here. Those people do not have authorization necessarily to do that. And frankly, even if the contracting officer is telling you to continue working after you've exceeded the ceiling or the funding amount, or even generally if it's in an agency that's shut down, they don't have the money, that CO could be violating the Anti-Deficiency Act, which is technically criminal. But it's it doesn't necessarily float onto you that it's criminal to continue working. But the point is that it would be at risk. So, and I know that's come up a number of times with people who think the work that they're doing is very critical, or they don't want to let the agency down. And technically it's not illegal to continue working, but you're doing it at risk and you might not be paid.
Yeah. And some of this stuff has just been hard because you haven't had anybody to ask during this time of shutdown. That the people that you need to get the permission from, they're just not there. Those butts aren't in the seats. And so you have to make those at-risk business decisions, whether you're going to proceed at risk and hope that the agency will pay you on the other side, or you're not willing to take the risk.
Or you may have not had a conversation with the agency in December to know where you are in terms of funding. So then it's just a matter of going into your financial accounting system and trying to do your best estimation at where you are and making a risk assessment based on what you can determine.
And this is a good one to think about now, because if we're up for another 3 weeks, there's a lot that can be done in the next 3 weeks, given the uncertainty that's just out there right now. Everybody's going to be crazy, I'm sure, definitely for the first week, but get as much of this done as you can now, so you're not in the same situation should the government go down again in a few weeks.
And make sure, if you don't know the funding amounts that's left on your contract, if it's actually been appropriated and funded, then I highly recommend, when this kicks back in, say on Monday, take this next immediate time period to figure that out, so you know where you are and chart out when you're going to run out of funding at a certain burn rate, so you understand how much you can work if this happens again in 3 weeks.
So can you enforce non-compete agreements to keep personnel? So, of course, the answer is maybe, or it wouldn't be up here, right? So in general, non-competes are only as good as the factual situation and how narrowly tailored they are. So if you have a non-compete, it really depends on where those people go and what they're doing. And you only have a non-compete that's enforceable if you have one of these protectable interests, meaning, and what's a protectable interest? That means your goodwill with your clients, or your confidential information and trade secrets, something like that. And there are arguments out there that if you're shut down and not working, how do you have a protectable interest to enforce a non-compete against somebody? But we all expect that this is temporary. And frankly, given the recent factual changes where we might be at work on Monday, if you had a competitor that basically was recruiting your people away because they could pay people during the shutdown and you couldn't, you very well have a protectable interest to enforce that, particularly because we expect to come online on Monday. So there are nice ways to remind people of their obligations and to also be sympathetic that they haven't been able to get an income. But at the end of the day, you can't expose your company to risk, and you need those people back online. So this is one tool that you might be able to use to get them back.
And now, what if your CO directs you to continue working? Can you bill now, or are you not going to get compensated until after the shutdown ends? You can certainly bill now, but you probably won't get paid. That may change in upcoming, hopefully they don't happen, but if a shutdown happens in the near future, OMB today announced they're considering revising their guidance to allow payment as long as money was appropriated to the contract before the shutdown happened. So if your contract has money on it, you would hopefully in the future be able to bill on it. As of right now, that it doesn't look like you would get paid if you submitted an invoice, especially because the people who are probably responsible for processing that invoice aren't there to do it.
So that's what's going to be interesting about this OMB guidance is that, okay, you changed the guidance. I can bill for it. I can get paid for it because my contract's funded. But is the person that's responsible for cutting my check in a seat? Are they deemed essential? And right now the answer is no. So I'll be curious to see how, if this guidance changes, how that will really play out.
Well, I know in recent years, more and more people have been deemed essential during shutdowns.
So what happens if your cash flow is short and you can't pay people? And this is, as the shutdown has gone on into, the second month, more and more of these calls are coming in. And frankly, that issue is not likely to let up for some contractors because there's still going to be a period of time where you're not getting paid by the government, right? Even if your people are working. And so the short answer is that if people have worked, you've got to pay them. And if exempt employees have worked even a part of a week, you've had to pay them for the full week. And we'll talk a little bit, I think, in a little bit about how we can use PTO and some strategies for that. The problem with not paying people is that you're subject to state laws, and the penalties are really, really harsh. One, they can go after officers and directors personally for that payroll. So if you think, well, I'll just declare bankruptcy, bankruptcy may not help you. It's likely not to help you when it comes to paying wages. They're going to come get it. They're going to take the house and the car and the boat and the, you name it, in order to get people paid. The other problem is that a lot of state laws provide for treble damages. That means 3 times the amount of damages. We just looked at a Minnesota statute that provides up to 15 days of additional pay in addition to penalties. Your employees go out and get lawyers because they need to get paid. You're going to have to pay for their lawyers too. So the cost starts to rise very quickly. There are banks in different jurisdictions. There are a lot of entities out there that are trying to make cash more available to businesses during the shutdown. We would encourage you to look at those resources, but take the second mortgage on the house if you've got to.
We have a somewhat related question, Nicole.
Okay.
Are employers required to keep paying for benefits when their cash flow is short like this?
Yeah, so that's a question we get sometimes too. It depends on how you have structured the furlough or the layoff. So if you've effectively laid people off, then your folks, even if it's a temporary layoff, your folks can essentially go on COBRA, meaning you don't have to pay even your portion of the benefits. Your employees, in order to keep their benefits, would have to pay full freight. Some employers, if employees are not temporarily laid off, or they're working part-time, have said, well, we'll pay our portion, but you still got to pay your portion. And if employees don't pay in their portion, then their benefits stop. So it really can depend on how you've structured their layoff effectively, or if you're keeping them on part-time and how you want to do that.
And what is, just so people understand, like if you're furloughing people, is there a difference between a furlough and a layoff? And how does furloughing or laying people off impact this issue of having to pay people?
I'm using furlough very loosely. It really doesn't apply in the commercial, even government contracting context. We use it a lot when we're talking about government employees, and so we tend to carry that term over when we're talking about contractors. But it's really a choice between you're reducing somebody to part-time, or you're putting them on leave without pay, or you're laying them off. And for unemployment purposes, and I'm sure a lot of your folks have gone out to apply for unemployment. Unemployment offices, depending on the state, like to see certain terms. And in order to get your employees out of applying for other jobs, a lot of states like to see temporary layoff as opposed to even leave without pay or a reduction in hours. So you should be paying attention to where your employees are.
And make sure, to that point, if you're furloughing people or temporarily laying people off, right, that you need to do that if you don't want to get hit necessarily with owing back pay and all the penalties that Nicole was talking about. So if you're not clear on what's happening to the employees, you could be on the hook for certain payments, even if, God forbid, something happens to the company that it falls apart because this were to drag on for months or something, and some companies we know of are having very serious issues. And if you didn't take the effort at the beginning, or the step, I should say, at the beginning to do the temporary layoffs, thinking, well, I'll just ride this out and I'll try to be really nice to my people, that's laudable. But if things don't come back online fast enough for your company and the company goes under, like Nicole said, you personally are on the hook for all of this. And so it's sort of, no good deed goes unpunished.
Mm-hmm.
And then it can get confusing if you have some contracts that are cost reimbursable, some contracts that are firm fixed price. And as Cy has written many a blog on this, firm fixed price doesn't necessarily mean the same thing for every contract. So how do all these different contract types and provisions affect your obligations right now? Well, in terms of whether to perform, it still comes back to, is the agency open and have you received a stop work order? Then going forward, depending on what kind of contract you have and what provisions are in that contract, you may have different options to help you recover costs. You may be able to have different obligations and strategies. For example, if your contract is firm fixed price, but you get progress payments depending on what milestones you reach, you may be able to recover some money in the future. But if your contract just says you get this amount per month, no matter what, that's a different calculus unless your period of performance changes. And then, as we said before, when you have the cost reimbursement contract, you're going to be watching the ceiling and making sure you're not exceeding the ceiling, whereas firm fixed price, regardless of how much money is on that contract, you still have that obligation to perform.
Yeah, and the other thing for firm fixed price contracts that I know can be rather confusing at times is depending on how the contract is written. Let's say it's firm fixed price to do certain work, like manning a booth, a receptionist desk, or something like that, and you have to put in, the contract says you have to put in 8 hours a day. Right?
23 seats filled every day.
Yeah, every day, something like that, in a specific number of hours. But you're saying, well, it's firm fixed price, so I bill the same price every single month. And the government, let's say, reopened, say it's only 2 weeks out of the month, the government was shut down. People are going to work. That doesn't necessarily mean you can bill for the full firm fixed price. And that's very difficult, I think, for some people to understand because it seems like it's a misnomer. But if it's firm fixed price for a specific number of hours or specific tasks, and some of those tasks are not done or some of those hours are not completed, then it's generally considered non-conforming services. And so you only can invoice and be paid for the portion of the work that was actually completed. So just something to remember, keep in mind, barring an REA or a claim, which we'll get to that stuff in a bit.
Yeah. And we have heard that during the last shutdown, some contracting officers on firm fixed price contracts worked with companies to find ways that they could produce the deliverables or make up some things. But you should be thinking about right now about what you can propose to your CO in order to make up that work, so you can try to capture the full amount you expected to on this contract.
Yeah, is there a mod you could propose, changing the period of performance, changing the payment schedule? What kind of options does your contract give you?
So can you pay salaried employees for partial weeks of work? And the answer is generally no. If you have a salaried employee, they have to be paid for their full work week because that's the benefit of giving them a salary and not paying them overtime. The downside of that is if they work, it doesn't matter if they work 20 hours, 30 hours, or 60 hours, they're supposed to get the same salary for all of those work weeks. You can, there are different strategies that you can employ right now or in the future for mitigating some of that cost. Leave is one way that you can mitigate it through the use of paid time off. You could also think about salary reductions for temporary periods of time. There is some risk associated with some of these options. Some of our clients were able to move all of their work into 1 or 2 people, 3 people, and then lay everybody off essentially until they could come back online. So you really have to look at your workforce. But if somebody has been called back to work for 3 hours on a Tuesday, they have to be paid for that full work week, and most people are out of their paid time off at this point. So you should be thinking about, I'm not going to, I got to pay this person for the full week, so that needs to go into my cost of them being called back for 3 or 4 hours.
Okay, I'm going to ask you a couple of related questions that have come in, Nicole. Mm-hmm. What about any federal holidays that have happened during the shutdown? Are people going to be paid for those?
So it depends on what you've promised to people and whether they were working under prevailing wage laws or not. So holidays are generally a discretionary benefit that you're not legally obligated to. But depending on how you've promised to pay people and whether they're considered temporarily laid off, whether they've worked a little bit, that can impact whether or not you need to pay somebody for that holiday. And I'm assuming most everybody's thinking MLK Day because that happened in this pay period. So you should be thinking, did I have those people on temporary layoff? If I did, I probably don't need to pay them for that day because they were temporarily laid off. But if they performed some work or they weren't laid off or furloughed or however you put it, maybe I do have to pay them. If they were working on a prevailing wage job, then there are rules about when you have to pay that holiday and when you don't have to pay that holiday. Give me a call. I'm happy to work through your specific situations, but that's the non-answer. That's the non-lawyer answer to that question.
And we've gotten a couple of people asking if you can convert people from salaried to hourly and then convert them back again.
So that's I'm not going to say it can't be done, but it is much more risky. So the way that the Department of Labor looks at that is you essentially risk your exemption for the entire period that somebody was working, right? So DOL says that you can do it, but if you do it, it has to be for a period of time, and it can't look like you're treating somebody as hourly all the time. So it's a little bit more risky. We have structured it for that way for a couple of clients. I would say that is probably the more risky of the scenarios than, for example, reducing somebody's salary to 50% based on a reduced workload and not pegging that to a specific number of hours.
And this is like a crossover too, what we talked about with either if it's a time materials or cost reimbursable contract, or if you've got a firm fixed price contract with some specific number of hours. If the people come in and do partial work in any given week, you might be on the hook to pay them for the full week if they're salaried people. But and maybe you did that, you put everyone on salary because you said this is a firm fixed price contract. Firm fixed price is firm fixed price, so I know what I'm gonna make, not necessarily realizing or looking deeply into the contract to notice that, well, maybe the government does have an argument that it's a non-conforming service because it was only a certain number of hours, not the full number of hours that was allowed. In those cases, you might have to pay the person, but won't necessarily be able to get reimbursed for the full amount. But again, it's very fact specific, depending on what's going on. So it just depends.
So if you're performing, and we touched on this earlier, but people that you need, who are normally there to on the government side are not there. How does this affect your performance, and does it create concerns? It introduces risk into your performance. If you require approvals at different stages and no one is there to give you that approval, then you can't, if you move forward, you run the risk that in 2 weeks someone's going to come and say, we never authorized that. This version isn't correct. You haven't fixed this bug. Go back and restart. And then you're going to, be behind in your performance, potentially out a lot of time and money. Similar things with if you were performing and your period of performance ended and no one is there to exercise the option, you're technically performing without a contract. So you are at risk there. So those are the kinds of situations where if you needed the government to sign off on something, or you need information from the government to be able to move forward, you're waiting for the next, input, the next volume, the next, research that they were supposed to provide you so that you could do the next step in your performance. If you don't have that, that's going to, delay you. You may be in the future be able to submit some kind of REA or claim for that delay because you weren't at fault for it, but it'll depend on the specific facts of your situation.
Yeah, and I think that the general rule for these sorts of things, Michelle and I have talked about it a number of times, if we're looking at something and you need certain employees, if the government is open, and let's say you need an employee to unlock a door, for instance, and the government is open, and that employee doesn't show up to unlock the door, then the government could be liable for you for basically breach of contract or not cooperating to open the door when you need to be. But if the employee doesn't show up to open the door because it's a shutdown, then in that case, there's something called like sovereign acts, right? Sovereign acts are a carve-out, generally speaking, for when the government is not necessarily liable for breach of contract because they took an act of the sovereign. And something like this that's required the government is required, the Congress and the president, to sign bills and pass laws, that is definitely a sovereign act. And in those cases, if the result of the employee not showing up is because of a failure to do something or some other act by the sovereign, then that exempts the government from liability. So generally, we'll get into a little bit more about certain maybe workarounds or wiggle room in a bit.
So a related question we have is, if I had a software subscription that's about to expire, the government wants us to renew it, but no one is there to pay for it, what should I do? In that hypothetical situation, if there is a provision in the contract saying, this is a requirement, once you do this, you get reimbursed for it, you could renew that software now. You probably won't get paid for it in the near future. Just like if you have an equipment lease that's up for payment right now, it's probably not going to get paid. But, document everything.
Yep.
To the extent, no one is there, still send an email, ask, and you make it an auto response. I've gotten this with, different people I've worked with in the government who say, I'm not here, but if you need immediate assistance, contact that person. Send it to that one, see if you can get approval. And if not, at least you've documented it. So when you try to get reimbursed in the future, you have a good paper trail that you did everything. You did your best efforts and you were just trying to meet the requirements of your contract.
And that would be different than, say, if your contract language said, okay, you can go out and get A, B, or C, but you need specific approval before you can go and get A, B, or C. In that case, you don't have anybody to approve. You're not approved until you get approval. So that, again, that's where the, combing through all of those words really can make a difference as to what your chances are for getting paid. And it's it might not be an issue if everybody's happy with the software solution at the end of the day. The problem is when you went and got something that maybe the new CO that got assigned to this 2 weeks, right before the shutdown didn't really like all that much.
Or there's been an update somewhere in the system and that software is not going to be compatible anymore, but you don't know because the person who was there needed to tell you that is furloughed.
And you're still going to want to get paid and the government's not going to want to pay you for it. So those are when the issues probably come up more often than not.
And then options. We're going to talk about options later. Like the other thing, if they have an option period, right? If you're up for option, say it was supposed to be renewed last week and nobody's there to renew it. And you say, well, I know they told me 30 days ago they were going to exercise the option.
Or you got an intent to renew, but it hasn't been renewed.
Per the FAR, which they should have been doing. Let's say they followed the law and they did that right before the shutdown happened. And then you're like, well, they were going to do it anyway, so I'm just going to keep going. Well, that's really at risk because if nobody exercises the option, the government always has the right to not exercise. And so if no one was there to exercise it, then it has not been exercised. So your contract does expire. Now, these are situations where if the CO comes right back and is like, oh, thank goodness, here you go, here's the option. There's legal questions, I think, as to whether or not you can, the government actually, if the contract actually expires, whether or not they can exercise an option later, because technically it's almost a new award. Now, these are issues that I'm not sure have necessarily been tread clearly, but just know that generally speaking, since everyone or a lot of people are in the same boat, my guess is that the practical reality is that they're going to come back, maybe exercise options, sort of turn the contracts back on whenever they can, and then you'll just start working and it would pick up where it left off, most likely.
This has been a very popular question coming in about requiring employees to take paid time off. It's been the number one question.
Yeah. Employees either love this or they hate this. And so it depends. Yes, you can. The short answer is yes, you can require employees to take their paid time off. That's a benefit that you gave to them, but it's not at their discretion. It's at your discretion. The only exception to that would be if you had some language in your PTO or vacation policy that said, we are not allowed to require you to take it whenever we want you to take it. And frankly, there might be some collective bargaining situations out there where you have that kind of problem. Now, some employers really want to force employees to draw down on all of their PTO because and some employees really want to take all their PTO. And the opposite is also true. Some employers don't have the cash flow to allow employees to take all their PTO. They have to stop it. And you can also limit the use of paid time off if you would like to limit the use of paid time off. So there are a lot of different moving parts, and every employer is different with respect to whether they want to force PTO, not force PTO, whether they can afford to pay it, whether they can't afford to pay it. But it really is a benefit. Now, depending on what you've promised to employees, PTO can become wages under state law. So take a look at your policies and what you've promised to people to make sure that you're not, running afoul of any of those rules or regulations.
What if you don't lay off employees or have a temporary layoff and the employees have PTO in the bank and you tell them, though, don't come to work? Or what if you do lay them? That's one issue.
Yeah.
What if you do lay them off, but they have PTO?
So that's why it's really important how you phrase the layoff. And you want to phrase it as a temporary layoff as opposed to a permanent layoff, because I know quite a few of you have promised payout of accrued PTO upon termination. So you don't necessarily want to term them. You want to keep them on your books so that you don't have to pay out all their PTO. You just want to if you don't have cash flow, you want to push the pause button, right? And not have anybody take the time off. The other thing you should consider, and employees sometimes don't consider, is that if they want a vacation, 5 months from now, they're not going to have any leave, and this might impact their ability to collect unemployment, or they're going to have to pay it back. So there may be reasons employees don't want to take the leave as well, because they don't want it to impact their down the road situation. So, we see all sides of this, but you have a lot of flexibility here depending on how your policies are written.
And I suspect the answer is going to be it depends. But are employees accruing paid time off during this shutdown?
Most often not, because most employers base their accrual policies roughly based on the amount of work somebody put in. Now, if you have essential employees that have been working, they're going to be accruing time. But if folks aren't working, generally they're not accruing time. Again, you might have promised people something different. You might work your accrual systems, in such a way that if you've promised people, it depends on how the promise is, but it depends on how you've promised people their leave. But most employers accrue based on time actually worked as opposed to time not worked, and make it pretty clear in their policies. For example, if somebody took a long FMLA leave of absence, generally you're not accruing during those periods of time either. So that might be a good benchmark to look at. How do we do it during long-term periods of absence like FMLA? That would be probably a good way to figure out, a path forward. But we can certainly talk to you about creative ways to solve that problem.
And can you require employees to start logging their leave without pay once they run out of PTO?
You don't necessarily want them logging into your systems. You want them completely off your system. So particularly because you don't want anything to be construed as working time that you're going to have to pay for. Now, some administrative, like I call you on the phone and tell you to come back to work, or I talk to you about your work status, is not going to be paid time, right? That's just general employment stuff. But logging your time in certain administrative tasks can be seen as working time. So I would have somebody else in your office, jot down that leave without pay time.
And another question we've been getting is about getting paid even if you're not working right now, if you're under a stop work order. So you're probably not going to get paid when the shutdown ends for what you would normally be paid, because you're not at, whatever agency performing. However, there are ways that you could get paid. We're going to get into some requests for equitable adjustment, also known as REA strategies, shortly. But we haven't gotten a question that does relate to this. Like, if you are standing by currently because, the government could open this afternoon, it could open on Monday, and you need to have people ready, and, they have clearances, and you have all these costs, these standby costs. That is one of the things that you can try to recover through an REA down the road. So you may not get paid what you would normally getting paid under your contract, but you may be able to recover some of these costs.
Yeah, so how can I minimize employee-related costs? So I think Cy and Michelle touched on this. You have an obligation, yes, you can recover some of these wind-down costs or startup costs, but you also have an obligation to minimize your costs while you're in a shutdown. So you don't want to be in a situation where you receive a stop work order and you just said, hey, everybody, because I need you up and running whenever this shutdown ends, I'm just going to keep paying you, and then I'm going to turn in an REA for everything, for all that time that you missed. you're probably not going to get paid for all that. You have an obligation to minimize your costs or reduce the cost to the government. So we have kind of touched on some of the ways that you can minimize those costs. You can look at, and these are hard because you also know your employees and you don't want to hurt your employees, but you can look at what are we doing for benefits? How can we reduce that benefit cost? Can we put people on leave without pay? Can we give them the option of either using their PTO, or should they be going out and applying for unemployment? What are some overhead costs? So I know there were folks that said, yeah, I had to temporarily lay off my direct bills, but what about your overhead costs? How are you managing your overhead costs in light of the shutdown? And are there any costs there that I can minimize? You also might want to think about segregating your costs, right? So making sure that it's clear that if you have an overhead person in the office, that they were working on one particular contract as opposed to another contract during that time. So you really want to be thinking about, am I doing what I can to minimize the cost of the government and doing my good faith efforts here while still protecting your workforce and still understanding that, and being sympathetic to the situation that everybody was in. And that can be very, very difficult to balance.
Yeah, and to that, it's kind of touched on the last thing we talked about too, but if you have a situation where you're promising the employees that you'll pay out their leave when there's termination or when they depart your company. If you're in a situation where the company is really, really not doing well, and it looks like there could be bankruptcy or just closing your doors, even if you don't have debts, something like that, to the extent that the employees were promised leave, and even if you're shut down and then they depart, I guess a question is, let's say they're temporarily laid off. Do they get that back leave, or is it what if they find another job? You would have to pay them, right?
Yeah, because once you've promised, now keep in mind in most states, you don't have to promise people leave as a payout. So somebody could accrue, 180 hours of leave. And if your policy says once you're not with us anymore, you don't get that. Most states, other than California and maybe one other, say it's fine. There's no rule that says you have to pay people at that time. It just depends on what you've promised people. But if your policy says that, yes, I'll pay you out, that then becomes wages under most state law. So if you get into a situation where you have to terminate people more permanently, you're going to have to pay out those amounts. And that becomes wages under the law and would be treated just like, an hourly wage.
Right. So people could come after you personally. And that's another example of it's absolutely a nice thing to do. And I'm sure employees like it. But just be aware that if the worst happens, sometimes people can turn, right? It's no longer, oh, you're being nice anymore. It's, wait, you owe me this money and my family's hurting. So I'm coming after you. And I know you have a house and a car or whatever else. And they can come after that.
And then, we've been focusing a lot here on prime contractors, but what about subcontractors? Are they required to perform if the prime isn't getting paid? So the first question is the prime performing? And if the prime has been shut down and gotten a stop work order, the prime, hopefully your subcontract has a flow down provision, and that gets flowed down to the subs, and then the subs wouldn't be getting paid because they're not performing. If the prime is still performing and not getting paid by the government, just like the employment situation where the contractor doesn't have the same benefit as the government, the prime is probably going to have to pay the sub. If you have a pay when paid provision in your subcontract, there may be an argument that the sub does not get paid until the prime gets paid. Those are really a question of state law, and depending on where you are, it may or may not be enforceable.
And a lot of states will just say, like, okay, you have a pay when paid clause, but that doesn't mean you don't get to pay forever, right? So the question is a matter of, like, how long is it going to take you to pay? And we've definitely had cases where the government made it clear they were never going to pay you for A, B, or C. And that doesn't give us a right to go to the sub and say, well, since the government's not going to pay us, then we're not going to pay you. A lot of states require some form of payment, even if the prime doesn't get paid.
And we've gotten a question on what recourse does a subcontractor have if it's been under a stop work order. Should it be part of a prime contractor's REA, or should it be going after the prime? What do you think, Sai?
I mean, depending on if the subcontract has a provision in it that the prime is required to like pass through claims and things like that, even if they don't have it, then you could seek it and go through the REA process or a claim directly to the government or indirectly through the prime, but file it with the government. Now, if it's something where the prime contractor just didn't communicate effectively or didn't give you a stop work order or something like that, and you could still perform your work adequately under the contract, then you might have a claim or a lawsuit potentially against the prime that they owe you, regardless of whether they got paid by the government or regardless of whether they got shut down, because the contract between the sub and the prime, without excluding like specific provisions to the contrary, is just a private contract. It has the impact. The shutdown has no impact. So just realize that if you're a sub, you are owed if you do work, unless there's something in the contract that says something to the contrary, or they've given you stop work per the contract.
I think that makes sense. And now, what should we all be prepared to do? Because people are chiming in here and saying that it's over. So what do we do now?
Well, I think we mentioned a few things. It's over. It's over only right now, I think, is lasting for 3 weeks. That's the last I heard. So I know Trump had a press conference, I think, at 1:30 p.m. and announced this. So
he must have known we were scheduled to do this at 2.
Right.
But keep in mind that all of those same issues that were on the table yesterday are still on the table for discussion tomorrow, and they're all very hotly contested issues. So one of my recommendations would be, first of all, think about how you're going to recoup some of the costs that you've had and what costs you might be able to recover, which maybe means looking at your contracts very carefully, thinking about creative ways, as Michelle mentioned earlier. How can you get a mod to extend period of performance or get those deliverables done so that you can make up some of that work? How are we going to best recover from this? And the third thing I would suggest you do is think about what to do in another 3 weeks if the government goes down again, or in 6 months if it goes. Keep in mind, this is the third time the government shut down this year. You just probably weren't very affected by the first two because they happened for one night or over a weekend. But, there are things that maybe you were unprepared for because of the length of this shutdown. As far as talking to your CO, figuring out what your limitations are in your contracts, getting your accounting house in order. What are you going to do for employees? How are you going to treat these situations for employees? What kind of policies do I have in place? Do I need to change those policies? Right? Those types of things you should be thinking about now. So if this happens in the future, you're best poised to survive it.
And if this loss of incoming revenue for this period of time has affected your operations, how is that going to affect your indirect rates? How is that going to affect your cost structure going forward? What can you do in the future? What adjustments do you need to make for the future?
And I think both guys touched on it, but communicating with the COs and the government personnel, like Monday, they're going to get flooded, right? But make your best efforts to talk to them within this 3 week period, sooner rather than later. If you've got options upcoming, or if you've got some of these leases or equipment or the new license for this, all this stuff that people were asking about and we were talking about, try to communicate and get answers on that stuff now. Because if you get an answer from a contracting officer saying, go ahead and do it, and that you get it done during this 3 week period, then any of those recurring costs, you might not get paid. Let's say there's another shutdown, God forbid, for 2 weeks or 3 weeks or something like that. You might not get paid for those weeks right in the moment, but you would have a very good claim potentially for the cost of these ongoing leases and things like that afterwards. But it has to get all that done now. Even if options are going to be exercised in week 4 from now, try to get it done and actually signed sooner rather than later so that it can extend even if we get shut down again.
Now, do you show up on Monday if you got a stop work order, or do you need to wait until you receive a formal lifting of the stop work order from either the agency or the prime?
Yeah, you would. You
need a formal lift.
Yeah.
So you got, it's very possible that you won't, hopefully those go out right away. And what we've kind of heard, same with the getting the stop work orders, we've heard that a lot of times COs, they're going to be overwhelmed, and who knows how quickly they can get. And you might get a call that says, when are you here? And you're like, well, I haven't received my lift. Like, I need notification that I can start working. You want to press that. You might want to alert somebody like, hey, I'm waiting for my notice that I can start work. Because if you have a salaried group of employees, you're going to have to pay them for the full work week next week. They're out of leave possibly because you let them burn through it all, right? So you want them putting in a full work week next week. So you want them like, let's hit the ground running, which means do everything you can to get the paperwork in order. Make sure you can proceed.
And email, things like that are okay. So, but it has to be the contracting officer. So if you hear from your specialist or something like that and says,
Program manager.
You're good, program manager. Yeah. Or definitely people like lower. And they say, go do this. We need you here. We're ready to go. Start. That doesn't necessarily mean anything. The CO could ratify it later, but just know it's at risk. Now, I can guarantee you there's going to be a lot of that, and people are going to want to perform in order to be a good contractor and make sure the government's happy. And that's perfectly fine. That makes a lot of business sense. But just know that if the CO wakes up on Wednesday and was like, well, I didn't give you this. I'm getting Monday and Tuesday and Wednesday for free. Start work tomorrow. Then you're doing it at risk.
Okay, now the big topic, REAs and claims. Can you do that? As we've hinted at, yes, you can. REAs and claims, I can encourage you to go back. And a couple years ago, we have webinars specific to REAs and claims. But these all revolve around provisions in your contract or different FAR provisions. So the main ones here you have are the ones that deal with suspension of work, stop work orders. And those are the kinds of things that allow you to recover your standby costs. Some, maybe you have a lease that you couldn't break, costs that were basically unavoidable during the shutdown. If you have employment policies in place that require you to keep people on, anything like that. So what do? You should hopefully have documentation for everything. If you've had people working just as much as they can, hopefully they've been logging what they've been doing. You have all that documentation together. You've been gathering it. You've also got documentation of what you've done to minimize your cost. Maybe the announcements you sent out to people saying, take your paid time off, or giving them options on what they could do, to help lower your cost during the shutdown. Then you can prepare an REA or a claim. It's not as generally as simple as just submitting an invoice. You have to put together a narrative, cite the relevant provisions in your contract or the FAR that support you, and then it goes into the contracting officer and they can pay it out. For a request for equitable adjustment, attorney fees and consultant fees are generally recoverable. So if you want to engage counsel to help you do that, we do them all the time. And it can, take some of that load off of your back while you're trying to get back to work and get back down to business.
Yeah, and I think everybody wants to know, the exact list of things that they can put into each bucket. And I wish we could email all of you the specific list and give you a spreadsheet and say fill in number here. It's not that easy, and a lot of it depends on, again, to Michelle's point, what you had to do in the duration and what you didn't have to do. And there's just not a one size fits all for that.
The kind of contract you're performing, even if you are on a construction contractor working on a levee in, Southern Illinois, it probably made sense to keep your core crew on site and those standby costs be recoverable. If you're an IT contractor whose people live in the DMV, the DC area, and you're performing in Tyson's, you can't recover those people's housing costs because those are regular costs, but maybe you had them doing work related to the contract back at your home office. If you've documented that may be something that you can recover. So it's unfortunately very fact dependent.
And it will matter going forward, I think, as we look toward what might happen in the next 3 weeks too. This is another thing you might want to put on your, if we're in week 2 and we still don't have a deal after the government's reopened, should I be asking my contracting officer specifically? I have employees that are in X country, and it's going to cost me $20,000 to have them stop work and bring them back. If I just leave them there, it's going to cost me $5,000. What do you want me to do? You have a much better, position on a claim than you would otherwise. Not to say that you couldn't recover that cost if you make that decision, but that's another one of those things. Think about in the next couple of weeks, are there costs that I might need to talk to the CO about now? Like, these are things that happened to us during the last month and a week, and so I want to be prepared for them should this happen again.
And that's good too, because if the CO directs you to keep certain costs going, then that would also help you if this happens again or you had to enter into an REA. Because the other thing that I've seen COs and the government love to do when you submit any REA, in particular in an instance like this, or a claim, they'll look at the costs, and if you get somebody who's really intent on negotiating, they'll look at them and say, well, sure, I get that this type of cost was necessary, but was this amount necessary? Or I want all the information you have about how you mitigated this cost. If it's like equipment, they're going to ask you, well, how difficult would it have been to get this equipment back? Did you try to lease it? Did you try to sell it? If you knew that here we don't know it's going to necessarily go on for a long period of time, but depending on the fact pattern, in certain instances, let's say you knew it was absolutely going to be like Congress left, right? You knew it was going to be at least a week. If there's some reasonable step you could have taken to mitigate the cost, to lease it, sell the equipment, you buy it back or whatever, there's potentially an argument the government could come back and push you on those issues and say it was unreasonable for you to keep that on here because we might be on the hook for this cost, but after 2 days, you should have realized that this was going to be shut down. You should have cut that cost. So we'll pay you 2 days, but not the remainder. Things like that. And I've seen the government be really, really aggressive on some of these issues in the past. So just be aggressive too when you're trying to mitigate.
And we have time to go through a couple of questions that have come in. I think it would be helpful if we clarified what we were saying about firm fixed price contracts, because there's a little bit of confusion about how the government could refuse to pay a firm fixed price contract if there aren't hours required and that kind of thing. So could you explain, Cy?
So yeah, what I was talking about is, in particular, there is a clause, a non-conforming services clause in firm fixed price contracts. And if they take issue with some aspect of your performance, they can either force you to come and fix it, or they can go get it somewhere else, or ask for a reduction in price based upon the non-conforming work. I mean, the obvious example is like if I tell you to paint a room blue and you paint it red, I'm not going to pay you for that work. I'm going to make you come back in and paint it blue, and then I'll pay you, right? Or if you paint half the wall and I want the whole wall painted, I'm not going to pay. And I say, forget it. Here's half your money, right? Because you didn't do what was expected of you. Or they could say, we're not paying you any of the money. We're going to go to someone else to do it and terminate you, right? So that's where we're talking about it. And the most common way I see it is in instances where the contract says, we need you to come in and do the work, and we want you to bid how much it would be for 2,000 hours of work. And you bid a price, and then it's firm fixed price. So you don't get any more than that. That's all you get. And then people go on regular vacation, paid leave, and things like that. No problem. But what if people go on unpaid leave? Or what if someone quits and finds another job and you can't hire someone to backfill for 2 weeks? The general rule is that if you were supposed to do a specific number of hours and you don't do it, then the government can basically refuse to pay, even if it's firm fixed price, for any of the non-conforming work. And in the hours, the problem with the hours is the reason they tend to not pay is they can't ask you to come in and fix it because you can't turn back time.
So what about, just to give you a real life example, like I have a janitorial contract and I am supposed to have, I'm supposed to clean 4 floors Monday through Friday, from midnight to 6 a.m. And I'm supposed to have the contract is structured for a period of performance. And it doesn't say hours necessarily. It says the hours during which you can have janitors there to clean those 4 floors. I would imagine that's one of those scenarios where I can't go back. The government's been shut down for, 5 weeks, whatever it is. I can't go back and clean those 4 floors of that office building during that 5-week period, unless the contracting officer was willing to extend my period of performance or something like that, in which case I would be working longer. My contract was set to end in October. It would now be set to end in November or something like that. So I could still get that same amount of work in. But if I can't do that, they could say, well, no, I'm not going to pay you for that 5 weeks that you weren't cleaning that office building, even if it's firm fixed price.
Right.
Right.
Especially if it's, let's say every month, you're supposed to do it once a week, and the government's been shut down for 2 of the weeks. Then again, that goes back to non-conforming services. That sounds harsh because it was non-conforming because the government shut down, but that goes back, you layer on top of the non-conforming services clause the idea of a sovereign act. So the government's not liable for the shutdown because it's a sovereign act and you didn't do the work, so you're not owed the money. So, and the work you did do in that month was non-conforming. Again, ridiculously harsh, but if the government wanted to push it hard, that would be the argument that they would make. Now, depending on the clauses in the contract and the terms, sometimes you have FAR clauses, but then you have other clauses that have nothing to do with FAR regulations at all. It's just language that someone in the agency drafted. In that case, if there's wiggle room in there, you might be able to make claims for some of that other work, but it depends on the specifics of the contract. In your case, where you didn't even do the work, it would be difficult under any circumstance, unless the language is very odd. But
and that might be different than you're supposed to build, you're supposed to build a software system, and maybe I wasn't working for the last 5 weeks because it wasn't funded, but I can build that software system for you in the time I have left in my period of performance. That might be a completely different scenario where you might be fine. It just, again, it's all those darn words.
Right. Well, and if you worked, like say you're building a software system and you told your people to keep working, then when the government reopens, let's say your deliverable was due next Friday. If you had stopped, there's no way you could have gotten it done on Friday. But if you actually worked and incurred the cost and got it ready to go and you deliver it on Friday, you're going to be paid for that entire deliverable, all of that software, because you did the work.
Yeah.
And it doesn't matter that you were working, because it's firm fixed price based on what you do, the output you do. In those cases, you can get paid for that work.
Yeah.
No, I don't think it's really a question in that aspect. I think we're out of time.
I think we're out of time. We got so many questions, and we thank you. We know this is like the forefront of your mind, and I'm sure even if the government's back up and running as we expect it to be on Monday, we'll get more questions. But we will do our best to answer these questions as quickly as we possibly can. And we hope everybody is up and running and this is over and we don't shut down in 3 more weeks. But hopefully we gave you some good information going forward.
And call your senator and tell them to pass the Stop Stupidity Act. Period. That would save a lot of heartache forever. So our kids and grandkids never have to deal with this nonsense.
And you can find a copy of this webinar on the website. And we don't have a version with answers for you, but we do have a YouTube channel where you can access the recorded version and share it with anyone that you want to share it with. So thank you, everyone. Have a great weekend. Hopefully everything's back up and running Monday, and we'll be here to help you do that.